Good morning, good evening, good afternoon, whatever time zone you're in. So, a couple things. First of all, it's been brought to my attention that Frauditor Troll has paid over $30,000 to his attorney. Now, as I previously established, he hired a boutique attorney, and you're going to pay boutique attorney prices. So it's not surprising to me that he's paid $30,000 to date, and he's going to pay a lot more. He's going to pay a lot more. Sometimes the process is the punishment. People have also said that the only reason why DMA is doing this is because Randy's doing this for free. Randy's not doing this for free. I have not seen the contract between DMA and Randy, and I am speculating, but based on what I know about attorneys in general and Randy in particular, I'm going to go out on a limb here and suggest to you that Randy is doing this on a contingency fee basis. He's probably in it for 1/3 to 50% of whatever DMA's recovery is. Plus, I'm gonna guess, because this is just based on all the contracts I've seen, he's also entitled to all the attorney's fees recovered. So Randy is probably going to come out of this with a fair bit of coin in his pocket if this goes the way Randy thinks it's going to go. And he's going to come out with some coin in his pocket if he gets the attorney's fees. So he's not doing this for free. Attorneys generally don't do things for free. It is rare that you'll find attorneys who will do things for a pro bono. Usually pro bono is done for like Special Olympics and things like that, nonprofits that an attorney is somehow involved with. It is rare in my experience to see any attorney do things for free. We do this for a living. It's like a mechanic fixing your car for free. They don't do it, generally speaking, unless they're your friend or something. It's our job. Lawyers do this for a living. This is how we pay our bills. We don't do things for free, generally speaking. And I am 99% sure that Randy is not doing this for free. He's doing this for a cut, most likely, of whatever DMA recovers plus whatever attorney fee awards that he gets. So, and I'm going to guess that he's doing this on most of the cases, if not all of the cases, for copyright that he's representing clients on. He's most likely doing them on contingency fee basis. So, I mean, you haven't seen the contract, so you can't say that Randy's doing it for free, but Randy doesn't seem like he's the kind of guy who does stuff for free. Also, because Randy hasn't done a trial doesn't mean Randy isn't a good attorney. Most attorneys haven't done trials. I've done trials, but I work for 3 law firms, plus I have my own practice, and in family law, domestic violence, civil harassment, those all have a high probability of going to trial. So, just because Randy hasn't done it, most attorneys haven't done trials. Randy's had a lot of cases that I've seen, and he normally hires, from what he's told me, he normally hires trial counsel because he doesn't feel comfortable in the courtroom, and that's fine. That doesn't mean he doesn't know what he's doing. Again, the work that I've seen him do has been adequate. It's been good enough to get the job done so far. So let's put that baby to bed. He isn't doing it for free. But okay, the next thing is I'm going to forget her name. I want to say Rachel Good, the gal who got shot by the ICE officer. That got brought up. And first of all, let me say that I never, ever, ever celebrate anybody's death. Now, the person who brought this up, out of the blue, did celebrate Charlie Kirk's death, which I find interesting, and also made the statement that Miss Good was innocent. Well, there's only 2 ways you can interpret that. Either she was legally innocent or factually innocent. Legally, she's always going to be innocent because she's never going to be tried for any crimes because she's dead. We, as a nation, we don't charge people for crimes posthumously. They're dead. It's a pointless thing. The court isn't going to entertain it. You can't punish someone for a crime that they committed after they're dead. You can't do it. So it's a moot point. She'll never be tried for it. So she will always be legally innocent. But if you extend that logic out and you want to say that this person was saying that she was legally innocent, well, every single person who died before they were convicted is legally innocent. Congratulations. So hey, Hitler, legally innocent. He's dead. He's never charged with anything. He's never convicted of anything. He's legally innocent, right? Every bad person who's died in a shootout with the cops, innocent. Everybody who managed to conceal their crimes until they died, innocent, right? It's nonsense. So I'm going to assume that this person was saying that she's factually innocent. Well, maybe not. But I'm going to talk about the legal side of things, not the political side of things. I'm going to talk about the legal side of things. Legally speaking, she had been detained. The cop had most likely, almost certainly, probable cause that she was obstructing a federal police officer. It was like 18 USC 111, or is that assault on a federal officer? I don't remember. Anyway, almost certainly obstructing a federal investigation by blocking the road with her vehicle. At least probable cause to believe that. Whether or not that was her intent, I don't know. You're not a mind reader. I'm not a mind reader. I can't tell her intent, but I can tell that she was with protesters, that her wife was a protester, that she seemed to be very happy to be blocking the road. So I'm going to guess that the cops could, at a bare minimum, establish probable cause for obstructing. They ordered her out of the vehicle. She refused that command. We all know Pennsylvania v. Mims, or Mims v. Pennsylvania. I always forget which order it's in. Cops can order the driver out of the vehicle. If they have probable cause or even reasonable suspicion, which is even a lower bar, they can order the driver out of the vehicle to conduct their investigation. So she's resisting, obstructing, whatever it is, multiple counts of it. And then she drives at a police officer. Now, whether or not she intended to drive at a police officer, I don't know. I don't care. I'm not a mind reader. You're not a mind reader. The cop's not a mind reader. The judge isn't a mind reader. But what she did was she drove at a police officer. You can't do that. Let me just go ahead and make a blanket legal advice for anybody out there. Never drive your car at a cop. Never, ever, ever drive your car at a cop. That is licensed to get shot. Just don't do it. Like, they're going to shoot you. I have seen countless videos where cops have shot people who are driving at them, who are dragging them. Like if the cop has been getting in the car door and the suspect starts driving away with the cop trapped there, the cop will shoot him. And that happens. It is lawful. You cannot assault a police officer. You cannot do it. They can use force, up to and including deadly force, depending on the circumstances. And a car is, I don't know any place where a car isn't, let's just say, considered not a deadly weapon. Every place I know, a car is considered a deadly weapon. If you hit someone with a car, as long as they can prove intent, that is assault with a deadly weapon. If you assault a police officer, a federal law enforcement officer, and you actually make contact with them, that's a felony. So now she's a felon. Not only can the cop shoot her because she's assaulting him with a deadly weapon, not only can he shoot her for that, most likely, and get away with it. I mean, maybe some circumstance will come up where all of a sudden that amount of force wasn't justified. Not only can he do that, but there's also a doctrine about shooting felons who are known to be a danger to the community and in possession of deadly weapons. And to that cop, a prima facie example of her being a danger to the community is her driving into somebody with a deadly weapon. So if you're intending to say she didn't intend to do it, it doesn't matter. Irrelevant. That's not a fact that's before us. You're not a mind reader. I'm not a mind reader. The cop isn't a mind reader. The judge isn't a mind reader. No one knows what was going through her mind, except for bullets, obviously. No one knows what was going through her mind when she decided to hit the gas. She did hit the gas. Her car hit a cop who was in front of her vehicle when she hit the gas. QED, quod erat demonstratum. It was, unfortunately, a clean shoot. Now, Michigan has a record of show trials. Speaking of show trials, Maduro, that's going to be a show trial. I mean, their original complaint alleging he was the head of a drug cartel. I mean, I'm not a Maduro fan at all. I hate communists. They're scum, and that's great. And I don't also support what Trump did, kidnapping him. But irregardless, Maduro's going to be a show trial. They're amending the complaint, or they've amended the complaint, because the original charges that they were going to charge him on was that he was running a drug cartel, and like all of a sudden they realized that he wasn't. So, but whatever they do, unless there is a political change, he's going to get convicted in a show trial. But Derek Chauvin in Michigan, that was a show trial. The knee on the neck thing, that was common practice. Blah blah blah. It was a show trial. Whatever you think of it, again, it's tragic that someone died, but whatever you think of it, that was a show trial. I understand that Michigan wants to make this ICE agent into a, I don't know, sacrifice for the angry mobs, and they're intending to bring charges against him at the state level. Well, that's not going to go so well for him. First of all, if they bring charges against him at the state level and they actually get him and arrest him, there is a federal statute that allows him to have the criminal case removed to federal court. So they're going to eliminate the state court, the state judge, and he would be in front of a federal judge. Then, excuse me. The next step is that there is a rule. It was established all the way back in like 1850 when a marshal who was protecting a judge in California shot and killed someone who was threatening the judge, but that person ended up not having a weapon. And I think it was in San Joaquin County. I could be wrong on that. And California was going to bring charges against this marshal, and it went up to the Supreme Court, and the Supreme Court says no. If the officer reasonably believes that he is doing his duty, then the state can't do jack shit to him. And there is no way that I can see where a reasonable judge would find that officer was not engaged in his duty as an ICE agent. That I cannot imagine that, because again, they had probable cause that Miss Good was obstructing the road and obstructing it in particular to prevent ICE from conducting whatever ICE was doing that day. So the stop was almost certainly justified. I can't see how a reasonable judge would find it was not justified. The order for her to get out of the vehicle was justified. Her attempting to obstruct further by fleeing, evading, whatever, her driving into the cop in itself was a crime. The cop shooting back was justified. So I don't see this turning into a show trial. At most, it's going to get, if the state does actually bring charges, it's going to get removed to the federal courts, and the federal courts are going to dismiss it because of that immunity that he has in conducting his duties as a federal officer. Even if the state disagrees, sorry, federal law is supreme. The state can't overrule the federal law on that. So anyway, so there you go. There's your long-winded answer for why Rachel Good, number one, was not actually innocent, even if she will forever be legally innocent, and it was a clean shoot. So if you have an ideological disagreement with that, if you think that it was unjustified because of who she is or what she represented or whatever, that's irrelevant. This is just the law, and take it or leave it. Thanks for watching. Have a great day.